My lord, for correction,
What correction?
my lord, there is a my lord, typographical mistakes. The dated, my lord, and it is since that the matter was settled, my lord, on 17th February 2018, and it has been mentioned, my lord, 2013, my lord.
Mark it, mark it,
My lord, penal market,
mark it and give it to.
my lord.
10th to be mentioned. What should be the right year? Mark it there. 2018.
18, my lord. Deeply obliged.
Amicus in this matter.
Mr. Mukherjee. In this matter, Mr. Mukherjee, no. CRR 1477 of 2012.
CRR 1164. No, my lord. Sorry, my
Hmm.
my lord.
And in that matter also, issue has been set at rest. Mr. Mukherjee has lent his assistance and I have addressed the issue. देखिए এটা রাখুন, I am passing it over, sir. দেখি কি আসে। সৌরভ, this revisional application challenges the judgment passed by learned additional sessions judge, fast track first court Krishnanagar in sessions case number 49 within bracket 8 beyond 04 and session trial number Roman 10 of September 2004. Briefly stated, the victim lady was of 15 years when she was deflowered by her neighbor. She was deflowered by her neighbor, Aurobindo Mondal, with a promise to marry her. The victim became pregnant. Police was informed. Became pregnant and Aurobindo Mondal disowned the responsibility. Stop. Police was informed and Tihatto police station case number 95 of 2004 was registered. After investigation, police submitted charge sheet against the accused person under section 376, 417 of the Indian Penal Code. The accused person stood the trial, pleading his innocence to the charge under section 376 by 417 of the IPC. Learned trial court. After considering the testimony of prosecution witnesses, was pleased to record an order of acquittal. According to learned trial court, the victim at the time of occurrence had attained the age of discretion the victim is PW1. Narrated that how she was forced to indulge in physical relationship with the accused persons who promised to marry her. After she conceived, the victim disclosed the incident to her mother. The man disowned his responsibility. Shalish was held at the village where the accused person refused to marry her. The doctor PW Ken stated that he that the victim was carrying a baby PW 5, Dr. Parthulod. ওটা হবে যেটা বলেছিলাম না PW 10, ওটা হবে PW 11. Held ossification test of the victim girl at Krishnanagar, Shaktinagar Hospital as a radiologist, and opined that the victim was aged about 16.5 years to 18 years with allowable margin. Margin. The doctor PW 5 was not cross-examined. Therefore, the prosecution has admitted that the victim was aged about more than 16 years. Thus, I do not find any reason to interfere with the order impugned. The revisional application does not merit any further consideration and is dismissed, however, without proceeding. It's here, Lord, copy of the judgment. ওটাও পাঠাতে হবে না, পাঠাতে হবে না। মহিলা বিয়ে হয়ে গেছে। Let's call the next one.
But I'm for the petitioner. But I've not been able to get in touch with the client, well, it's an old matter. But we'll kindly. keep
So
it
all
up.
matters are old, madam.
I'll try to reach to the client in the meantime and get.
After vacation,
After vacation.
come prepared,
Definitely, ma'am.
suggest a date.
But any day, as per your lordship's convenience.
Your Miss Patel,
Yes, ma'am.
Saurabh Babu, had learned counsel for the petitioner, who is seeking an accommodation. The matter is adjourned to appear on 7th of June. In the meantime, please get in touch with your
I will.
client.
Grateful, lordship.
Item 4, my lord, I was praying for a short pass over, my lord. The de facto complainant, my lord, Miss Chandrayalam is also present here.
Pass it over.
Great.
Well, 5 and 6 have for the opposite party, my lord. Mr.
It's an assigned matter.
Assigned better. No, my lord, I think this. Oh,
My lord, the petitioner has passed away.
Petitioner has passed away.
I think, my lord, there are একটা না তো অনেকে আছে খালি petition number 1 has perhaps passed away.
In both the matters,
My lord, Mr. Mitta is representing Vishwanath Malik, one of the petitioners. He has passed away.
देखिए file to them.
My lord, it is that matter where a GA is also pending.
Yes. G is also pending and perhaps it has been assigned. I don't. Take. Mr. Shovik Mitter is not available in High Court. That's the report of department. Where is he gone?
It's going to Jalpaiguri.
When?
Yes,
Not found, dated 12th of April 2023. What is this?
I'll inform Mr. Mehta.
You should receive the. "26th of September 2008, he died." What's the subject matter?
Sir, this is revision against acquittal, my lord. We were acquitted.
Revision against acquittal.
Sir, next director matter.
In such a case, if the petitioner dies, then what do you want to do?
Revision becomes infructuous, sir. Petitioner has died. Substitution to order the book.
Take further instructions from the.
You have challenged the judgment. You were not the accused person. That with your death, it should be abated. This is revision. Does it come to an end with the death of petitioner? That is the point. You are the de facto complainant. What about the victim?
I have not been engaged in the matter. I do not know the fact.
Anyway, these are the points. So what is your take? It should be thrown overboard.
If they have to make a substitution.
Yes.
If they don't make the substitution.
Then it will go. So you have to take the call,
Lord, I'll take further instructions from the client.
please. And what about the GA? Hey, এটা কি আমাদের কাছে আছে? Item number 6. GA has been assigned, no?
My lord, after
Who is appearing for the state? There is a GA.
5 or 6. 6. Vishwanath Murli.
এটা রাখুন, I'm adjourning it. Post vacation.
Post vacation.
Come back with instruction.
Yes.
Saurabh Babu,
Come on, Mamata.
office report indicates that the petitioner Vishwanath Malik died on 26th of September 2008. Matter is adjourned to appear on 7th of June under the heading for orders. Learned counsel for the petitioner
The opposite partners.
is also seeking accommodation for further instruction.
No, my lord, kindly record.
To come back with further instruction. And
My lord, and record
Yes.
my presence.
yes, hard learned counsel for the petitioner and learned counsel for the opposite. GA টা ওইভাবে রেখে দিন। 7th of June. GA তে none appears for the state, ওই adjourn করে দিন to appear on 7th of June.
Lord, I am for the petition.
Hmm.
I am tendering apology because I could not come within time, my lord. Well, it is a revision. Case is under, offense is under, punishable under section 354 IPC.
No, first you tell me,
Yes,
have you complied with the direction of the coordinate bench?
yes, my lord. There is a direction for to serve the notice upon the other side. But this is my lord latest evidence of service.
It is served.
It is served only, there is upon the state only.
Why?
Because there is only state, but it's the state versus case, my lord, and Last one from now.
It is barred by limitation.
Yes, my lord. This was barred by limitation. Delay is 240 days. 240 days delay to file the revisional application. I don't know whether I couldn't recall whether the application has been allowed or not.
No,
No. Then my lord, limitation application. My lord, kindly first at first taken up. My lord, kindly limitation application. My lord, I'll come to page 5 of the limitation application, my lord. Paragraph number 8.
three 54 concurrent
My lord,
finding.
Well-
Concurrent finding of
yes.
order of conviction
Order of
recorded against
conviction
you.
That was affirmed by the
First
appellate
you,
court.
first you address me why this judgment should be interfered with, then I will condone your
Lordship.
delay everything.
Lordship. Well, for my first thing is, my lord, offense incident took place on the date of the 15th February 1999. Complaint was lodged by the de facto complainant after 5 days, that is 22 1999. There is no explanation in the complaint. Number one. Number two is this: when the incident took place in a school, matter was according to the de facto complainant, matter was reported to the school authority on 17th February after 1 day. But the victim reported the matter to her mother, that is a de facto complaint, on the self-same day when the incident took place. There is no number. Next point is, my lord, in the written complaint was complaint was scribed by the
Who is this petitioner?
petitioner is the accused, my lord.
No, no, accused, I
Oh, as a
understand.
relation. He's a group D staff of a school, local school where the victim studied. And my lord, in the written complaint, there is nothing in the mentioned. There is no mentioned in that was same was read over to the de facto complaint, and that was written in according to the version of the de facto complaint. This was not written.
How old is the girl?
At that point of time, according to the ossification test, at that point of time, she was 14 to 15 years old, as was report of the ossification doctor. She read at that point of she read in class 6 or 7. আপনি আছেন এটা? আপনি আছেন? ও আচ্ছা, আপনি আচ্ছা আচ্ছা বলুন। আচ্ছা, আপনি rest নিন, rest নিন।
Do you have the deposition? Do you
Yes,
have
I
the
have copy, but
deposition?
that is not a certificate copy. I have copy of the deposition, that is not a certificate.
Victim, এটা কি LCR এসছে? Do you have the testimony of victim?
Yes,
Just let me go through that.
yes, my lord, I'm giving. কি?
Then to
My lord, I may be excused for the time being, my lord. I'm coming.
পড়ে যাচ্ছে।
Aditya,
PW3 টা PW3 is the victim. হ্যাঁ no, no, মানে এখন করা নেই আমার তাহলে সিপি করে দিলাম ফটো দিয়ে ঠিক স্টেট কপি নিচে দেখুন স্টেট appear to be fully complete.
Very well, sir. You
Yes.
go through the testimony of PW3
Yes,
and say why this impugned judgment is not justified. Yes, take this.
my
Adito, at the din.
lord, charge was actually
I will come to that part later on. You just read the, have you read?
yes, my lord.
You know
Yes.
ins and outs. Now tell me why it should be interfered with.
My
Why should I disbelieve this victim girl?
my lord, the victim girl said that after the incident, matter was reported to her mother.
What about the incident?
Oh, acha. What about the
What is the cross examination on that point?
there's at that point I can't change the evidence. my
So
lord.
you have admitted.
That I can't change the.
No, there is no merit. Yes, take down.
On that point, there is no.
There is no point to interfere with. Had learned counsel for the petitioner. There is a delay of 240 days. Stop. I have the benefit of going through the testimony of PW3, who is the victim and who narrated the incident as to how she was allured by the petitioner, who, you are doing a mess. I have the benefit to go through the testimony of the victim who had narrated as to how she was পুরো ব্যাপারটাই আমার মাথার বাইরে চলে মন দিয়ে পড়েন না কেন she narrated as to how she was her modesty was how she was allured by the petitioner who promised to give her the question papers of annual examination to secure a good result. Stop. In her testimony as PW3, the victim stated how her modesty was outraged by the petitioner and there is no cross-examination. Stop. Therefore, I do not find any reason to entertain the application for criminal revision condoning the delay of 240 days.
My lord, may I submit one thing?
Yes,
My lord, conviction is 1 year and some amount of fine, but may I submit that delete the conviction and fine amount may be enhanced? My lord?
Mr. Then I have to admit your revisional application. That I cannot do. I am not going to accept that. Go and serve out sentence. She was a girl of 6 years, 14 years old.
14 years old.
Money cannot buy anything and everything. No. Go ask your client to.
And my lord, then will kindly record my submissions.
Yes, yes.
On which point I am listening this.
You have to cross the threshold, sir. Then I will enter into the merit. What was their delay, etc., etc. Why should I just see the testimony and the way she was cross-examined? Virtually, you have admitted everything. It is submitted by Mr. Mondal, learned counsel for the petitioner, that delay may be condoned, comma, order of conviction may be maintained, but sentencing part may be interfered with. Instead of asking the petitioner to undergo imprisonment, fine amount may be enhanced. Stop. This is a case where a girl of 14 years was fallen prey to the lust of the petitioner. Stop. I do not find it is a fit case to interfere with the sentencing part as well. Stop. The revisional application is disposed of. Petitioner is directed to surrender to the jurisdiction of learned trial court to serve out the sentence. Stop. Copy of the order be sent down to learned trial court. Serve out the sentence within 4 weeks. Within 4 weeks. Copy of the judgment be sent down to learned trial court for information and necessary action. Sorry, with a better case next time.
My lord, the item number 7 and 8, my lord, I am paying for not receiving, my lord. My lord, in this matter, my lord, the litigant, my lord, is an old age man, my lord, of 75 years, my lord. We can, for some health issues, my lord, we
You
cannot.
got to assess the court. I have got nothing to do with
My
the
lord, and my
petitioner in
lord,
person.
Mr. HON'BLE Mondal is in this matter, my lord, he is at Jalpaiguri bench, my lord. My lord, kindly, my lord.
এটা করে দিন, not this report.
My lord, grateful.
My lord, I am praying for short passover. Learned counsel is appearing on this matter. He have mentioning before another court. Kindly pass over this matter for 10 minutes.
11:30 সময় দেবেন। Taken up at 11:30. Otherwise, you will have to assist. Go through the brief. Go.
Wait, Your Lordship. This is that matter which I had mentioned on Friday after seeing the records. My lord, the lower court records have not come. Now, the accusation was put to the petitioner in 2006, and the judgment was rendered in 2010. My lord, it's squarely hit by 326(3), besides other points. So, my lord, I was humbly praying, since it's from Bankshal Court, I will put in special messenger costs by Wednesday, but tomorrow is a holiday. And my lord, let the records come from there.
Hey, it
My lord, I tell your lordship what has happened. People tend to forget that in all matters of conviction, the lower court records are necessary. And therefore, it is not even it's the advocate's fault for not asking for it when the matter was moved.
This is the order by 8 Metropolitan Magistrates.
My lord.
Sorabo. লিখুন তো। Heard Mr. Dostur, learned senior counsel appearing on behalf of the petitioner. Stop. This revisional application challenges the order of conviction recorded by learned 8th Court of Additional Metropolitan Magistrate, duly affirmed by learned Additional District and Sessions Judge, 9th First Track Court, Bichar Bhavan.
When it will be additional sessions, yeah.
Yes, Additional District and Sessions.
It's a district and sessions. Because Bichar Bhavan only has criminal.
That is what has been written here in
Oh.
your petition also. It should be Sessions Judge. Yes, Additional Sessions Judge Court in District of 9th First Track Court, Bichar Bhavan, Calcutta. The lower court record is still awaited. But the report is otherwise. Summoning, what summoning? Let me do one thing, sir, before department is directed to call for the lower court record. The matter, I'm fixing it post vacation. Matter is adjourned to appear on 8th of June.
I'm deeply obliged.
Let the department call for the lower court
Very well.
record.
I'm deeply obliged, Lord.
ওইখানে
My lord, I am praying for not this.
I have the benefit to go through the testimony of PW3 as handed out by learned counsel for the petitioner. Yes,
My lord, I am praying for not this week.
why?
Due to my senior was having some personal difficulties.
Who is your senior?
Sudha Mr. Shekhar Rai.
What about Mr. Shamanto?
I don't know about.
You don't know. What's the subject matter? Debopriyo Shamanto is the advocate on record. Where is Mr. Shamanto? Debopriyo Shamanto is the advocate on record. Where is Mr. Shamanto?
He is.
Yes, you have no business. Go. Don't show this audacity. Ready? দিন দিন এদের সাহস বেড়ে যাচ্ছে। She is instructing an advocate and you are encouraging all these things. Yes,
He has not yet came. He is on road.
he is
On road.
on road. Who is on road?
We should.
I am passing over the matter. Let him come back. Call the list. Aditya, order কোথায় লিখবো? দেখুন তো অর্ডারটা কোথায়? 31/1/2012 কিছু দিচ্ছি অর্ডারটা ছেড়ে। এটা বার করুন তো কোথায় অর্ডারটা আছে? ট্রায়াল কোর্টের অর্ডারটা হুম এখানে আছে, ঠিক আছে। देखो प्रभु एकदम despite service of notices, neither of the parties appears before the stop. This revisional application is pending since 2014. Stop. I do not find any reason to adjourn the case suo motu. Stop. Rather, I am inclined to dispose of the revisional application on merit. Stop. Para. By filing this application under consideration, the petitioner is seeking an order of quashment of the order dated 31st of January 2012 passed by learned Additional Chief Judicial Magistrate Srirampur, admitting the application under Section 12 of the Protection of Women from Domestic Violence Act 2005 in a proceeding in MC case number 29 of 2012. Briefly stated, Anjana Paul filed an application under Section 12 within bracket 1 of the PWDV Act against her husband Kaushik Pal and other inmates of her matrimonial home. Stop. Notice was served upon the opposite parties. Stop. The petitioner, being the husband, appeared before the learned trial court and prayed for an order of stay of all further proceedings on the ground that at the instance of his wife, Udayanarayanpur PS case number 312/11 dated 27th of December 2011 under section 498A 406/34 of the IPC, read with 3 and 4 of the DP Act, was pending. Otherwise, it would be an infraction to the provision of under Article 20 within bracket 3 of the Constitution of India. Stop. Learned trial court, after hearing both the parties, passed an order giving his reasons for not acceding to the prayer of the petitioner. The said order was challenged in criminal appeal number 7 of 2013, and the learned appellate court refused to interfere with the order impugned. Stop. The petitioner has challenged the order passed by learned SCJM and not the order passed by learned additional district and sessions judge in criminal appeal number 7 of 2013. Stop. Be that as it may, there is no bar under the law. No, the law does not impose any fetter upon the petitioners to take out application under the PWDV Act pending proceeding under section 498A of the IPC. The revisional application is devoid of merit and is dismissed, however, without cost. Copy of the order should be sent down to learned trial court for information and necessary action.
The item number 1, just the previous matter, my lord.
Item number
11.
11.
Your lordship, my lord, your lordship's direction, earlier direction was to serve the other side.
Yes.
We have already served and affidavit to service is already ready. I am asking for time, my lord, because of my busy schedule, my lord, the other course. My lord, on 15th of this month at 2 p.m. Next month.
What?
Next month it may be fixed for hearing.
You are seeking accommodation
Yes,
on 15th of May.
at 2 p.m.
Very 2 p.m. Sorry. 2 p.m. is earmarked for criminal appeal. You have to come during the first stop. I am adjourning the matter. Yes. Take
All
the-
right, in the first half I shall come.
You are Mr. Roy.
Yes,
Heard Mr. Royal and counsel for the petitioner who is seeking an accommodation.
Yes.
The matter is adjourned to appear on 15th of May as suggested by learned counsel for the petitioner. All right.
State is there, no? State is there.
State is there. Yes, state is omnipresent, omniscient. So come prepared on that day. Yes, call the list. You go. Yes. Hmm.
I'm bring 1 day accommodation.
Not today.
Much also.
Mr. Binoy Pandey is that.
Not today. Come on 10th.
Several times.
You and your friends. Oh. थोड़ा बहुत लिखे नहीं. Since the matter is appearing almost after 12 years, department is directed to issue administrative notice upon the parties. Matter is adjourned for 4 weeks with liberty to mention. No, 4 weeks. Hey, 4 weeks दिले तो out of list हो जाएगा. না, matter is adjourned till আপনি করুন আজকে হচ্ছে 8ই মে তো till 9th of June with liberty to mention. এগুলো এখন কোথা থেকে বার করে নিয়েছে এক্সকাভেশন?
And appearing for the petitioner in this matter, Your Lordship, I am led by Mr. Ayon Bhattacharya. I humbly beseech Your Lordship to fix the matter sometime after the vacation.
Why not today?
Specifically,
wrong with today?
specifically because of the factum that this matter is a very old matter and certain German instructions, Your Lordship, are required in this matter to get back on track. The matter is a matter of, Your Lordship, 2012 complaint case.
Have you? The matter is getting adjourned for last 2 years.
Your Lordship kindly fixes it after vacation. We will see.
Suggest a date.
We will
Suggest a date.
1 week after vacation.
No, yes, give me a specific date.
Specific date. I have to take instruction on that.
Go take
Or your
instruction
lordship
and
can,
come back.
your lordship can fix any date as per
No.
your lordship's convenience.
I don't adjourn the case to pass another order of adjournment. Suggest a date on which you will be comfortable. I will fix that on that very day.
Lordship, I'm praying for a short pass. I'll take. the
Yes, I am
instruction.
passing over the matter. Come back with specific instruction.
Great. Extremely good.
Yes.
I'm for the state.
My lord, Mr. Mondal is for the petitioner. He is unavailable today, so praying for not today.
Hollal Mondal,
Yes, my lord.
he will be coming back tomorrow.
My lord, the matter will be dealt with tomorrow.
Tomorrow.
I'm,
Not today, on 10th. Fine. What is your name?
Ayon Mondal, my lord.
অয়ন মন্ডল। ঠিক আছে, নামটা পাশে লিখে দেবো। কল্লোল মন্ডল না এলে অয়ন মন্ডল হবে।
জানা আছে, instruction আছে, senior আছে।
Same order. Maintenance, right? ধরুন তো এটা এখন শেষ করো। যা খুশি বাবারে, কি সব করে রয়েছে। হ্যাঁ, কি বল? এটা খেয়াল রাখবেন, এটা 11th 2 PM, হ্যাঁ অ্যাসাইন, হ্যাঁ ফাইল দিয়ে জাস্ট সহকারের সাথে কথা বলুন। This revisional application challenges the expertise order passed by learned Judicial Magistrate 6th Court, Alipur in criminal miscase number 228 of 1995 under section 125 of the Code of Criminal Procedure by the impugned order, learned Judicial Magistrate was pleased to direct the petitioner Vasudev Noskar to pay a sum of rupees, no, was pleased to direct the opposite party number 1 in the said proceeding to pay a sum of rupees 500 towards maintenance of his mother. Stop. On 14th of November 2005, when this revisional application was admitted, liberty was given to the petitioner to appear before the learned trial court within 2 months and pray before the learned trial court for setting aside the order passed ex parte against him, and learned trial court will decide the petition on merit. Stop. There is no indication whether the petitioner has complied, subject to payment of rupees 300 per month. There is no indication whether the said order has been complied with or not. Stop. However, in view of the order dated 14th of November 2005, the impugned order does not warrant any further interference. Revisional application is thus disposed of, however, without cost. Yes.
Hello, this is my application. Lord, I apologize for not making it on.
It's okay.
This is
You
my-
take the mic,
My lord.
make yourself audible.
My lord, am I audible now, my lord?
Item number 9,
Item number
file kothay apnar kache? Yes, what's the matter?
My lord, this is
Order
my
of
lord,
conviction
order of conviction, my lord,
in a proceeding under section
138, my lord.
1,
138, my lord, of the negotiable instruments.
138 of
Check
the
bounce, my
NIA.
lord.
Yes.
My lord, may I briefly, my lord,
Do you,
indicate?
do you have the copy of deposition?
My lord, unfortunately, I do not have copies of the lower court records, my lord. I am informed, my lord, they have arrived.
Oh, very good. It's with me.
My lord, my ground of challenge, my lord, may I indicate, my lord. It is really at this stage, my lord, very limited. Because, my lord, at the time that this revisional application was filed, one of my major grounds was that there are 2 statutory notices under section 130 that is impermissible in law. My lord, recent decisions of the Supreme Court now have negated this, my lord. I am not pressing that ground, my lord. That ground is now been settled by the Supreme Court. A check can be presented for payment several times over, and statutory notices can be issued on that regard. This is what happened in this case. So, my lord, at this stage, my ground is only one, my lord. That is here. This is a case where the discharge of liability, my lord, requires a liability.
Yes.
My lord, that liability accrued on a partnership firm, and that partnership firm has not been impleted in the entire proceeding. My lord,
How
this
has not been impleted?
partnership firm has not been
The,
impleted. My lord,
check was issued on behalf of the firm.
on behalf of the partnership firm, my lord, the agreement admittedly, my lord, it is the admitted position and recorded by both lower courts, my lord. That is the trial court and, my lord, the lower appellate court. Both courts have recorded that the agreement was signed and executed, entered into on behalf of the firm. And that is the admitted position. Therefore, my lord, my humble submission before my lord today is that how can I My lord, yes, page 45, 47, 6 onwards. My lord, I have a running page number, possibly that might not be. My lord, then internal
Anyway,
page, my lord, internal
I have
page 4.
found the application
My lord,
under section 138. Just let me go through it.
my lord.
The accused is a businessman carrying on various businesses. Accused is a businessman. Pavitra Ganguly is you are representing
client,
Pavitra
my
Ganguly. Is an existing partner of TV channel C Ren Company. Person published AVP and AVP. Where is the agreement?
My lord, the agreement, my lord, I unfortunately do not have a copy of the case because it should be exhibit 1,
But
my
the
lord.
averment made in the application doesn't support your contention.
My lord, it is admitted that the agreement was entered into on behalf of the partnership firm.
The accused is a businessman
My lord,
carrying on various businesses.
my lord,
Accused is an existing partners of TV channel so and so. The accused person published in the ABP seeking finance for profitable business for his company, namely so and so. After seeing the advertisement in the ABP, complainant invested a sum of rupees so and so in the year 2000, 2001. But the agreement made on 2nd of July 2001 on the said invested sum of rupees 40,000, and in the agreement, the complainant, whatever, there was a promise of return
my lord, will kindly take the agreement. my
at the rate of 5% per month
lord. My lord,
towards interest.
my lord, will kindly
It's
take
not
the,
that the partnership firm borrowed money.
my lord, a partnership firm did borrow money. My lord, will kindly take exhibit 1, my lord. I find from the record should be exhibit 1, my lord. Even though I do not have a copy, exhibit 1 should be the agreement. My lord, both
This is
courts,
the
my lord,
agreement
my lord.
when all the matters including signature of the accused person which may be exhibited as exhibit 1. Aditya, দেখুন না রোহিত কোথায় আছে exhibit 1?
My lord, I can also indicate from the impugned orders, my lord.
দেখুন এটা তো মনে হচ্ছে না লোয়ার কোর্ট রেকর্ডটা এসছে, এটা বোধহয় অ্যাপিলের রেকর্ডটা এসছে।
My lord, may I please from the impugned
Yes.
orders, my lord? From the impugned orders, it is admitted. This is a finding of fact by both lower courts, my lord, that the agreement was entered into on behalf of the firm. My lord, will kindly take page 29 of my application. My lord, will kindly take page 29 once. This is the trial court order, my lord.
Who is Ujjwala Majumdar? Ujjwala Majumdar is the complainant.
My lord, possibly, my lord. My lord, the complainant. Complainant.
Yes,
My lord, will kindly take the findings of the two courts, my lord. The two courts below.
but this exhibit 6, the check,
My lord,
carries the presumption,
my lord,
and now it is upon the drawer of the check to rebut such presumption.
my lord,
Clear?
my lord.
What is that evidence of rebuttal?
My lord, my evidence of rebuttal, my lord, is the admitted fact. My lord, what is that presumption, my lord? That presumption is of liability. My lord, if I can show from the admitted facts of the case that that liability was that of the firm, nobody is disputing this. My lord, the agreement is clearly
Now,
in the name of the
please-
firm.
Please indicate this 10,000 rupee check.
I do not have a copy, my lord.
This is exhibit 6.
My lord,
The check was dishonored. It was issued by your client
my lord,
in his individual capacity,
my lord,
not on behalf of the company,
my lord,
right?
my lord.
Now, you were to rebut the presumption that you did not have the liability.
My
You
lord,
come to section 139 of the NI Act. It is not that check was issued.
my lord, I am not disputing, my lord, that the onus was on me, my lord. However,
Yes.
my lord,
Yes.
I have made a clear attempt before the two courts below, my
No,
lord.
you
to
please
show
go through
130.
139.
My lord, may I please, my lord? My lord, may I hand over my copy, my lord? I can,
No, I have copy. Yes, it's with me.
my lord, 139. Presumption in favor of holder. It shall be presumed unless the contrary is proved.
Yes.
Unless the contrary is proved that the holder of a check
Hmm.
received the check of the nature referred to in section 138 for the discharge in whole or in part of any debt or other liability.
So
My lord, as
primarily, it indicates
my lord,
in discharge of your obligation, whatever the obligation we don't know, this check was issued.
my lord,
Now onus shift upon your client to rebut,
my lord,
to establish that there was no such legal
my lord,
liability.
my lord, here
Yes.
my only contention is, my lord, the liability, the presumption
Yes.
relates to a liability.
Yes.
My lord, that presumption only says that it is presumed that the liability is that of the issuer of the check.
Yes.
Here, my lord, the entire proceeding proceeds from that agreement, my lord, has seen as exhibit 1. The basis, the entire basis of the complainant's case, my lord, is that agreement. He is not contending that I am a guarantor. He is not contending that it is a separate agreement.
No. What is your stand before the learned trial court?
My stand is, my lord, that
Where is
implement.
that? Where is that? Did you file any objection? Did you adduce evidence?
But I do
How
not
did you
believe so,
rebut? Only saying that it was the company.
my lord.
Company has not been implicated.
My lord, it is my
I
humble
don't think it
submission.
will do.
It is my humble submission, my lord. I need not adduce any evidence at this stage.
Yes,
Since,
fine.
my lord,
It's
it is
absolutely.
admitted. My lord, since it is admitted that the agreement, my lord, the agreement produced before
No.
the court, my lord.
Where is the notice?
My lord, notice should be. Give me a second, my lord. First notice is exhibit 11, my lord.
Hmm.
Exhibit 11.
Did you respond to this notice? No.
My lord, I do not believe so, my lord. There is no, my lord. I had disputed service of this notice.
You have
I had disputed service of this notice, my lord.
service of notice.
I had disputed it. It was held against me, my lord. I disputed it. My lord, here may I make one submission?
Yes.
My lord, here
Notice exhibit 11.
my lord, 10 and 11, I believe, my lord, two
Hmm.
notices. Two notices.
Yes.
My lord, here, my lord, it is my humble submission, my lord, that no question of evidence can be gone into without impediment. It is a point of law I'm raising before my lord, not a question of evidence. Without impediment of the partnership firm, this proceeding is not maintainable in law, my lord. I am
For
carrying one
that-
judgment of the Supreme
For
Court,
that, you need to show
my lord.
that the transaction was between the company and the,
My lord, it is admitted. My lord will kindly take the agreement, exhibit 1. Exhibit 1, my lord, the agreement. It is nothing but an agreement, my lord. It is also on the letterhead of the company. There is no question of any transaction, my lord. No finding of none of the findings of the lower courts, my lord, have held that there was any transaction between the partner, that is my client, and the complainant, my lord. The agreement is purely between the company and the
how it was
complainant.
dealt with before the learned trial court.
My lord will kindly take page 29. Page 29 of my application, my lord, is internal page 3 of the trial court's order, my lord.
Yes.
My lord will take, my lord, the findings start from, my lord, the last paragraph. The last paragraph, my lord, at page 29. In order to prove his case, the complainant has examined on oath as PW1. In his examination in chief, the complainant inter alia stated that the accused is a businessman carrying various types of business, and one of them is CN Ren, a partnership institution, which is involved in the production of popular Bengali TV serials. On the basis of an advertisement published by the accused, different daily newspapers, the complainant invested on the basis of an agreement in the letterhead of CN Ren. This is an admitted fact, my lord. As per the terms of the said agreement, which was subject to renewal every year, the complainant is to get return of so and so, my lord. My lord, these facts are again reiterated. The original agreement is marked.
Evidence টা আছে একটু দিন।
My lord, this was also found. My lord, made me, my lord's pleasure to take up the lower appellate court's order once, my lord. It was found, this was a finding, my lord, of the lower appellate court, that it was entered into on the behalf of CN Ren. My lord, internal 3 of the lower appellate court's order.
এটার মধ্যে
My lord will kindly take the lower appellate court's order once, my lord. Internal page 3.
Have you gone through the testimony of PW1 during cross-examination, what she has stated?
No, I do not have a copy of it, my lord. I do not have a copy of it. My lord, I believe it should be the same as being recorded by the trial court, my lord.
I gave the amount to accused Povitra Ganguly during cross-examination. She is saying this. I think it's better you go through the
My lord,
deposition
I will take an inspection. my lord.
and you come back with
I will take an
instructions.
inspection, my lord.
There is a valid point that you were raising.
My lord, my
The-
point
the
is, may I just indicate one thing? I was carrying just one judgment, my lord. My lord, I am outside the point of evidence, my lord. I am not contending anything on evidence. My point is only on a point of law.
Provided the money was taken by the firm.
Money was taken by the firm.
Yes, but the cross-examination says otherwise. So better you study.
My lord, I
and
will
you
take
come
inspection.
back. You study and you come back. So far your point is concerned, it's okay. What judgment you are going to cite?
My lord, I was citing, my lord, 2012 5 SCC, my lord, on the point, my lord, that where
What's the
My
cause
lord,
title?
cause title, my lord, Anita Hada versus Godfather
Yes.
Travels.
And there is another judgment on this point.
My
So you were comfortable to that extent.
My lord,
If the money was taken by the firm. Now you go through the testimony of PW1, particularly during cross-examination, what he has stated, she has stated. Come back.
my lord,
There was total transaction of rupees 65,000.
my lord,
25,000 was paid,
my lord.
and the lady is saying, I gave the money to Mr. Ganguly.
My lord, on behalf of the firm,
That is what you need to go through.
I will do so.
It is her testimony during cross-examination. Okay. Ektu niye ninna. So when you will be coming back?
My lord, we will take inspection, my lord, by this week, my lord, keeps it anytime next week, my lord.
Next week.
Anytime next week, my lord.
You are Mr.
My lord, Shaunak Mukhopadhyay.
Saurabh
Shaunak Mukhopadhyay.
Guho
Shaunak Mukhopadhyay, my lord.
Mukhopadhyay. So
Mukhopadhyay.
always take the benefit of mic. Yes, heard Mr. Mukhopadhyay, learned counsel for the petitioner. The matter is adjourned to appear on, say, 17th.
My lord, 17th. We'll be able to take it.
Yes.
Much appreciated.
17th of May. 17/5/2023. Yes.
Much appreciated.
And Mr. Mukherjee, there is another point.
My lord.
A person can issue a check on behalf of even a company.
My
There
lord.
are judgments.
My
So study all those judgments and come
But
back.
I will do so. My lord,
Yes.
there my only, because of this judgment, my only contention was I could have been possibly made liable, vicariously liable for the company. My lord, but there must be impediment of the company. That is
That
my
is-
only point.
That is
my
your
only-
point. Had
Yes.
it been a case of lending money to the company,
My lord,
then your point is absolutely fine.
my lord,
If not,
my lord, I
so
will,
go through the testimony.
I
Yes.
will. my lord. Much obliged. my lord.
Call the list. Take down. Since the matter is appearing for the first time after 16th of November 2005, department is directed to issue administrative notice upon the parties. The matter is adjourned to appear on 9th of June under the heading for orders. এটা করে দিন। এরকম Mr. Roy, what is the status report? Direction was upon you. You appeared on 14th of February 2022. Take down. None is appearing. None is appearing on behalf of the petitioner. Status report has not been filed pursuant to the direction given by the court net bench. Stop. State is directed to obtain a status report regarding the proceeding being GR case number 278 of 2000 arising out of Murarui police station case number 46 of 2000 dated 28th April 2000 by Murarui police station by 18th of May. Don't forget. You take note of it. Call the list. Eighteenth of May, 2023. আবর্জনার মতো পড়ে রয়েছে ওগুলো। Same with this one. একই order করে দিন। Mr. Roy, now this is your Katwa PS. 127 কোনো মানে হয়? দাঁড়ান দেখি তো এটা dispose করবো একটু রাখুন আমি দেখি। File an application under section 1 this party number 1 case number 18 government but for the maintenance for the period of Take down. This revisional application challenges the order dated 9th of December 2010, passed by learned Second Court of Judicial Magistrate Katua. None is appearing on behalf of the petitioner. I do not find any reason to adjourn the case suo motu. Rather, I am inclined to dispose of the application on merit based on materials available with the record. Stop. The impugned order was passed in money execution case number 18 of 2009, for modification of the order dated 7th of June 2004, passed by learned trial court in Miss case number 9 of 1993. Stop. By the order dated 7th of June 2004, learned trial court was pleased to pass an order of stay in respect of mis-execution proceedings arising out of the miss case number 104 of 85, subject to payment of 50% of the arrears of maintenance till disposal of miss case 9 of 93. Which was filed for modification of maintenance allowance under section 127 of the Code of Criminal Procedure. Stop. Learned trial court refused to sit over the order passed by learned trial court. Stop. In my view, the impugned order does not warrant any interference inasmuch as a court cannot sit over the order passed by the court itself in view of section 362 of the Code of Criminal Procedure. Stop. The revisional application is bereft of any merit and is disposed of, however, without cost. Order of stay, if any, stands. Take the order of stay, কিছু ছিল কিনা একটু দেখুন। এক মিনিট। Order of stay, if any, stands vacated. Then correct. Baba, what is this? The matter is appearing after 16th of June 2011. Stop. Department is directed to issue administrative notice upon the parties. The matter is adjourned to appear on 14th of June under the heading for orders. Same order.
This matter is appearing after 12 years again. This is the first time it is coming before your lordship. Status report could be called for.
You are for the petitioner.
Yes, ma'am. There was a CRAN that time, my lord, which has not been pressed. Thereafter, not know what the status is.
Yes,
There was a CRAN application at last,
CRAN application.
which was not pressed in.
Okay, CRAN for what? Please allow the application pass the fresh interim order. What is the original proceeding under section? You have challenged.
Just let me find out. Give me 5 minutes.
Yes.
I'll do it.
So proceeding under section 498A34.
Just 5 minutes.
Twenty-five, 26 today. Same order. বলে দিন। আগে যেগুলো দিলেন না একইভাবে একই অর্ডার করে দিন। হ্যাঁ এটা হচ্ছে 17th of May 2011 বা আপনি ইন জেনারেল করে দিন অলমোস্ট আফটার 12 years. This is item number 26 perhaps. 26. একদম জেনারেল একটা করে দিন, ডেট স্পেসিফিক করতে হবে না, since the matter is appearing almost after 12 years. Department is directed to issue administrative notice. Matter is adjourned to appear on say 14th of June. After date থাক না হলে আবার এগুলো হারিয়ে যাবে কোথায়। Aditya Babu, call the next one. Exhumed.
Well, this is for questioning 498A after framing of charge. So unless the CD of the standard report.
Yes.
Your lordship won't be in a position to discuss.
Mr. Roy. Item number 25 take to name to. Same order করে দিন। Item number 25 same order খালি একটা লাইন অ্যাড করে দিন, state is directed to submit a status report 25. And the proceeding, if is there any order of stay?
Yes, sir. There is. By Justice Talukdar.
Yes, order of stay. Along with case diary. Along with case diary. Status report and to produce the case diary on the adjourned date. Okay, 14th of June, matter is adjourned to appear on 14th of June. In the meantime, state is directed to submit the status report and call for case diary. And produce the case diary, call for no, and produce the case diary on the adjourned date. Then for it, call the list next one. একই? Identical order. এটা just 26 কে replicate করে দিন। Mr. Bajpayee. Very good. ওটা একদম ওই just না দরকার একদম ওই adjourned to appear on 16th of June না কবে একটা ডেট দিয়েছি ওই 14th of June. Okay. Under the heading for orders. Instruction nahi honi chahiye. Yes,
But 28, my lord, that administrative notice may be issued, my lord. Stay order is there, my lord, on pass on 18 August 2011, my lord. Quashing of the 366. আমি petition আরে petition
for a period of 4 weeks. So to chole geche. Ekটু এ করে নিয়ে নিন না এটা। Item number, this is 28. 28. As the matter is appearing almost after 12 years, department is directed to issue administrative notice upon the petitioner and upon the petitioner, State of West Bengal is being represented by Mr. Basu, who is directed to produce the case diary as well as status report on the adjourned date, that is when 18th of May. I will.
after
That
vacation,
is 14th
after
of June.
vacation.
14th of June 2023.
Okay. 14
এরকম কটা আছে এরকম?
petitioner.
এরকম কটা আছে? হ্যাঁ। এইটা আর দেখুন পরেরটা দেখুন কি আছে, একবারে একসাথে করে দেবো। কটা আছে এরকম? এইগুলো ওই একসাথে করে দেবেন, আমি বলে দিচ্ছি আর কটা আছে। একদম একই রকম অর্ডার হবে, জাস্ট কপি। Since the matter is pending almost after 12 years, the department is directed to issue administrative notice upon the parties fixing 14th of June. Fixing na kore. List the matter on 14th of June under the heading for order.
Status report is required, my lord.
29, 30, দুটো হলো।
Which one is naam dila?
Well, 31 similar order may be passed, my lord. Case diary and status report is to be called.
এক কাজ করুন তো,
Yes.
আদিত্য এইটা না 25 এ যে অর্ডারটা করেছে 25 এ দেখুন, স্টেট ইজ ডাইরেক্টেড টু প্রডিউস, ওইটাই রেপ্লিকেট করে দিন in item number 31. হয়েছে, এগুলো শেষ হয়েছে, আরো আছে। আপনি ডেকে দিন, যেগুলো হিয়ারিং ম্যাটার আছে আমি বরং ওটা করি, এটা পরে সেকেন্ড কলে দেখা যাবে, বেকার সময় নষ্ট হচ্ছে।
Forty-four Lordship, I am led by Mrs. Patel. Lordship, kindly keep this matter after vacation.
Why?
Lordship. After vacation, Lordship.
Why?
Lordship, we were not able to contact the client. This is a very old matter. Kindly keep it after vacation. In the meantime, we shall seek instruction from the
After vacation means come back on 11th. Tomorrow is a holiday. Come back on 11th.
We do not have
Yes.
his contact number, Lordship. With his contact number, we have to send notice.
Court is to provide you with the contact number of your client.
No, Lordship,
Then-
we shall send a notice to him.
Do whatever you like, come back on 11th. Call the list.
Grateful, Lordship.
Yes. Call the- I don't want to.
Why should this lady suffer, my lord?
No lady should suffer for me. Yes, who is suffering?
Well, she got only, lordship took vacation tomorrow.
Yes. Tomorrow is a holiday. So you come back on 11th.
In June, my lord. She would like it in June.
How many days at the bar?
Lordship, I got my enrollment in 2021.
Oh,
Yeah, it's pretty senior.
it is 2 years.
Okay, দিয়ে দিন এটা item number কত?
I'm grateful,
Also,
Lordship.
item number
44.
44 ওটা করে দিন। Matter is adjourned to appear on 8th of June. In the meantime, do whatever you like.
Lordship. Obliged, Lordship.
final item two.
Do you drive motorcycle? Mr. Ganguly, you don't. Then why are you cutting the lens? Wait. Yes. 52 ওই করে দিন। Adjourned to appear on 8th of June করে। 8th of June. 52. 8th of June. একই আর আমি সেন্টেন্স গুলো রিপিট করছি না, ডেট বলে দিচ্ছি, আপনি ওই সেন্টেন্সে ডেটটা খালি বসিয়ে দিন। Another adjournment application in the pipeline, yes.
But I am for the petitioner. 60 HDFC Bank, my lord, default committed. We issued a notice under 138. To preempt filing of the 138 complaint, a criminal case is filed. My lord, he is a habitual offender because why I say this? Because for the same customer, I have filed washing application for different companies. For Axis, for India Bulls, this Joydeep Mukherjee. My lord, kindly sees repetition of complaint only.
He is working to any or benefit to you only. Please appreciate that also.
Lord, kindly comes to the
After 2014, no, you serve, Mr. Chatterjee. The matter is appearing after 10th of February 2014. So you serve and come back.
my lord. But you kindly keep after the vacation.
Yes. Since the matter is appearing after 10th of February 2014, the petitioner is directed to serve notice upon the opposite party indicating that the matter will be taken up for hearing on 12th of June.
This is a complaint case only upon the.
Yes, upon the
Yes,
respondent.
yes. Most okay.
Seventy-three, Lordship, I'm appearing on behalf of the petitioner led by Mrs. Patel, Lordship. Lordship, this matter also kindly keep it after vacation, Lordship. We do not have any contact with the client. We have to send notice.
ওই একই ডেটে করে দিন তো।
I'm grateful, Lordship.
Identical হচ্ছে, what was your earlier matter? 44.
44 and
Just ওইটাকে replicate করো।
Item number 81, Your Lordship, I am for the petitioner. I humbly beseech Your Lordship to fix the matter after vacation. Since German instructions have to be taken, this is a very old matter. If Your Lordship so suggests, I can indicate a date, Your Lordship. If Your Lordship so suggests, I can indicate a date, Your Lordship.
Yes,
Subject to Your Lordship's
you should indicate a date and remember that.
obliged, Your Lordship. 21st of June, subject to Your
It will
Lordship's
otherwise operate as estoppel by conduct. Okay,
21st of June, subject to Your Lordship's convenience.
31st of June.
21st of June.
21st of June. Very well. And what is your name?
Mondal.
Mondal. Learned counsel for the petitioner is seeking an accommodation. And what about the earlier one?
Earlier matter, also I am advancing similar prayer, Lordship.
What was the number? Learned Mondal, learned advocate for the petitioner is seeking an accommodation. Matter is adjourned to appear on 21st of June 2023. June 2023, as suggested by Mr. Mondal.
Great.
The order is peremptory.
Great.
Same is with CRR 779, item number.
That was item number 17, Your Lordship, the earlier one.
17.
17, 17.
We actually order apni 17.
And Your Lordship, one humble
17.
Indulgence, Your Lordship. Item number 82 also kindly passes the same order. Item number 81.
Have you ever read HON'BLE? Do you know? Have you heard of HON'BLE?
Yes, sir.
Yes. Rest when we will be off the air.
One humble indulgence, Your Lordship. In item number 17, may I get hold of the records to ascertain certain particulars about the petition? Grateful. Extremely grateful.
Lord, I am there. Miss Alok was there since morning, Lord. I was busy. But she is now busy in Justice Ghosh's court. But fix up a date on Monday, Lord.
Monday means 15th.
I'll inform her. Lord.
Okay.
If it is suitable for your Lordship. When does your Lordship next bench with Justice Sen, Lord?
I don't know. Maybe sometime in the month of June or July, not before vacation.
Oh,
thankfully.
So, Lord, 15th, your Lordship.
15th, yes.
Great.
Item number 4, huh?
Yes.
On the prayer of learned counsel for the petitioner, matter is adjourned to appear on 15th of May, 2018, 2023, under the first.
Great.
Where is this computer man? Aditya, এটাকে আর তো কিছু নেই, এটাকে অফ করে দিন।
लड़ा को दो आपने conviction under section 489 B and 489 similar sentence to suffer 5 years challenging that I have preferred the appeal two appellants are there before a lordship. On last occasion I argue on the point of if there is for a conviction under 489 B 489 C there has to have 489 B because without possession use will not come in play. Here we were acquitted under section 418 B but convicted under section 418 C. To bring home charge prosecution has examined as many as 7 witnesses out of 7 2 are independent witness of Caesar they are related to each other one is the brother-in-law of other. We were allegedly the prosecution case we were carrying FICN and at the time of carrying we were intercepted on acting on a source information and Caesar affected. That is the case of the prosecution. So, may I take your lordship to the and the seizing officer, arresting officer, and the part investigating officer the same witness. Last occasion I referred one judgment of HON'BLE wherein the Supreme Court has categorically said this is against the principle of fair and impartial investigation. And police is the interested party to that investigation where arresting officer, complainant, Caesar officer, and raiding team member is the same. May I take your lordship to the letter of complaint?
Yes.
Letter of complaint this was the de facto complaint was it was a suo motu complaint. This was lodged by PW1 of SI of STM. In producing herewith the accused person in custody, seized articles and other relevant documents. This is to state that today at about 2nd March 2016, in the afternoon received credible source information. 2 Malda-based fake Indian currency racketeers would be coming near the triple patti of Barabajar PS Kolkata with huge amount of FICN for trafficking the same to their associates. Immediately conveyed the information to the superior officers and a team was formed comprising with the officers and men and suspect of STF, Kolkata, including myself under the order of superior for the purpose of effective watch and raid acting upon the above input. Accordingly, had been to the said area along with the members of the raiding team member of STF with investigation kit and the source information started maintaining watch in the vicinity of the said area of Barabajar police station in search of the said traffickers of FICN from about 13:55 hours this afternoon, 2nd March 2016. During watch at about 14:45 hours, the source pointed out 2 persons as the trafficker of fake currency notes. We were looking for who were walking along Pragyapatti Street from north to south direction. One of them was carrying a black colored handbag and the other person was carrying a maroon light brown colored handbag. Instantly, we intercepted those 2 persons in front of the shop under the name and style Mahendra Singh Indrajit Singh, situated at 9 Pragyapatti, after disclosing our identity for the and the purpose. On being asked, the first detained person disclosed his identity as Muhammad Ubaidullah, alias Abdul, alias Mama, alias Adu, so and so. They are from address so and so. And another Malad discloses his identity as Sukuma Sharkar, alias Papai, the appellant number 1 here. Thereafter, I requested the crowd gathered around to be the witness of the search and seizure, which was to be conducted about the two detainees, none but Vaman Pandya of son of so and so, and Gunjan K. Mashtia agreed to stand as witness to search. Then I offered myself to be searched by the detained two persons before I started conducting search upon those two detainees, but both detained persons refused to do so. So let's kindly see the address of these two persons, these two witnesses, Vaman Pandya, PW2, and Gunjan K. Mashtia. These two persons are not from the vicinity, rather neither they had their place of business at that place, and these two witnesses are related. One is the brother-in-law of others, that will reveal from from their deposition. Whereas the other PW3, he denied any relation. Then I searched the person of Waidullah Sheikh Abdul Mama, black colored side bag he was carrying in his right hand. In the spot presence of the aforesaid two, observing all legal formalities and thereby recovered black color polythene bag, currency notes, denomination, so and so denomination, high quality currency, total 2,50,000 from inside the said black bag, being wrapped with the cotton bed sheet, and also found cash of 320 from the cash pocket, from the chest pocket of his wearing shirt. One railway ticket dated so and so from Malda town to Howrah for 2% amounting to rupees 130. White ticket number so and so was recovered from his bag. One black and lemon colored, green colored mobile phone of Samsung was Samsung make was also recovered from the chest pocket of his wearing shirt. All these articles were seized and seizure list of dated so and so prepared by me on the spot in presence of the named two witnesses and the detainee of Muhammad Waidullah Sheikh. The seized articles were packed, labeled, sealed at the spot, maintaining all legal formalities in presence of the witnesses and detained Muhammad Waidullah Sheikh. Seizure of the detainee namely Waidullah Sheikh, and the witness were obtained on the label pasted there. Thereafter, let's searched of the person, the second detainee namely Sukumar Sarkar, and the maroon and brown color handbag he was carrying in his left hand. One millet kindly similar, he was carrying the appellant number 2, carrying right hand. The bag was carrying right hand and another was carrying left hand. This is the version of PW1, the part investigating officer and the complainant. Carrying his left hand at the spot. In presence of aforesaid witnesses observing all legal formalities, they were recovered the black colored polythene carry bag containing 3 bundles of each, which contains 100 pieces of Indian currency notes. So and so from inside the bag, wrapped with one lungi and one shirt, and also 360 from the right side pocket of his wearing trousers. Accordingly, all the recovered articles were seized under another seizure list dated so and so prepared by me at the spot in presence of the above named witnesses and the said detainee Sukumar Sarkar. The seized articles were packed, labeled, and sealed at the spot, maintaining all legal formalities in presence of the witnesses and detainee Sukumar Sarkar. Again, signature of the detainee namely Waidullah Sheikh and the witness were obtained on the label pasted in each of the packets. On being queried, both the detained persons could not render any satisfactory answer as to why they were having in their possession of such huge amount of fake notes appearing to be high quality counterfeit notes and face value 4 lakhs. So, this is the FIR. Now, kindly, I'll take your lordship to the charge framed by the learned trial court later. Kindly comes to page 7, the deposition of PW1 and the complainant. On 2nd March 2016, I was posted as Sub-Inspector of STF Kolkata Police. I am presently posted at the same place at post.
You just point out the relevant portion.
Well,
You appeared before the learned trial court as
My lord.
defense counsel. Why so many adjournments to examine a witness? Any special reason? Prosecution?
trial-
Yes.
Trial, my lord, kindly see, my lord, the prosecution had taken all that.
No, why?
They could not bring the witnesses. They could not bring the witnesses.
Why part examination? PW1 was examined for say
That is, my lord,
for
kindly
15
see
days.
the examination in chief.
Why? That is why I want
That
to
is
know.
their prerogative, their witness, my lord. They
Their
chose to.
prerogative.
They chose to. And trial court, my lord,
It's the
granted
it's the prerogative of lawyers to get the witness examined for days
prosecution,
together.
it is prosecution, my lord. We, the defense lawyer, there before the trial court, my lord.
What did you do?
Especially,
Did you raise any
despite
objection?
there are direction, specific direction to expedite the trial, my lord. We are facing this problem, my lord. Even, my lord, 11 years, my lord, behind the bar, trial is, my lord, stalled. In the 307 years, 30 years, my lord.
Very good. Yes. Point out the relevant part.
My lord, I'll have to, my lord, place these three PWs, my lord, into.
Are you going to read out between the lines the
For this PW 1, 2, and 3, my lord.
between the lines?
My lord.
Very well.
Because here, my lord, I shall point out to your lordship, my lord, on what was recovered, what was
Fine.
seized. This
Carry on.
only this.
Please.
And race 5, I will not, my lord, because race 5, my lord, they are formal witnesses. I will not travel your lordship, my lord.
Okay.
Only these, my lord. PW
No,
1,
it's
2, and
not the case of traveling. Yes.
On 2nd March 2016, I was at my office in the afternoon. I received source information that two Malda-based fake currency racketeers were likely to come to Tribal Patti Bada Bazar with ill motive of trafficking FICN. I immediately informed the matter to my superior, who was the SOC, and in turn informed the same to the superior on written permission of the superior to conduct search and raid. OC formed a team comprising officers and constable of STF, including myself. I diarized the fact in GD of the PS and left with the team to carry out the information. Sources were contacted and asked to reach the spot. On arrival at the spot, I contacted the source. He was with me during search and seizure. We strategically posted our men to the vicinity of the area and were looking for the person who were likely to arrive. We started this exercise at about 13:35 hours. At about 14:45 hours, source pointed out two persons who were walking along Pragyapati Street from the north to south direction. After being pointed out, but kindly, this part is very important. North to south direction, Pragyapati. After being pointed out by the source, we intercepted these two persons in front of the shop, named Mahendra Singh and Indrajit Singh of so and so. After intercepting two persons, I disclosed the identity and purpose of myself and the team. They were asked to disclose their identity. At the time, one of them disclosed his identity as Ubaidullah of so and so, and other as Kumar Sarkar Papai of Kalyachak Malda. Some people gathered around us, and it was a business place and congested area. Kindly similar this part of evidence. Some people gathered around us. It was business place and congested area.
Yes.
We informed the local people that we suspect that two intercepted persons were carrying fake currency notes with them, and I requested any two of members of the public to stand as witness to search and seizure of the person as well as the bag they were carrying. At these two persons, namely Bhavan Pandya and another Gunjan Mashtia, volunteered to stand as witness. After that, we started searching Ubaidullah Sheikh, his bag and his bag, which he was carrying. So, carrying whether left hand, right hand, in person, that is not mentioned by this video. On searching this person, I found one mobile phone Samsung made from his trouser pocket and cash of rupees so and so from his chest pocket. On searching his black color bag, black color side bag, I recovered one black polythene bag which was wrapped with a multicolor bedsheet From the polythene bag carry, I recovered 3 bundle of 500 denomination of Indian currency notes separately tied with rubber band and 1 bundle of 1000 denomination in Indian currency notes, and each bundle contained 100 notes. It appeared to me that the notes were high quality fake currency notes. The total amount I recovered from Ubaidullah Sheikh was 2.5 lakhs. From the other chamber of the bag, I recovered one railway ticket, one dated 1st March 2016 from Malda to Howrah station, and the ticket was of 2 person, and the value of the ticket was 130. It was a general ticket. In total, I seized 10 items from Ubaidullah Sheikh. I prepared scissor list to that effect in my handwriting at the spot in presence of 2 witnesses and detained. I read over and explain the content of the scissor list to the detained person as well as the witnesses. They put their signature on every page of the scissor list. I also put my signature on every arrange the entire pack in the written GD number 39. So, this GD is the written GD. Admittedly, it is deposed by the investigating officer. This is the written GD. Now, kindly takes up page 1, the FIR, formal FIR. Third paragraph A, general diary reference number is 40, time 21:45 hours.
Third paragraph.
Serial number 338, formal FIR.
Okay.
This is reference diary.
GD number 33.
GD number, this is general diary reference, entry number 40.
Yes.
Time 21:45. Then information received time 13:25. GD entry number 33. So if this is the time 13:25, this must have been the GD entry number, the left GD. Upon receiving information, when they were about to leave for raid, this must have been that GD number. In FIR, my lord, kindly, my lord, page 2, the written complaint, first paragraph, started maintaining, third paragraph, last 2 lines. Accordingly, had been to the source and started maintaining watch in the vicinity of the said area, Bada Bazar, in search of the said traffic gas, FICN, from 13:55 hours this afternoon.
Yes.
Well, 13:55 hours they started. They were started blood the watch from the PO. They were at PO, and blood the left. This is 33 GD number.
Yes.
And return GD millet as per the deposition of PW1, that is GD number 39 of so and so. But here millet 1945 hours. And I shall millet take your lordship millet to the deposition in my cross. Millet kindly takes up the cross of Shukuma Sharkar of this PW. As a lordship got it, millet. Page number 23, millet. And deposition page number is 70. Deposition
23, yes.
Millet, the cross examination of worship brother on behalf of Shukuma Sharkar. I had taken this specifically. I initiated my first GD on 2nd March at about 3:25 hours.
At page 23.
At page 23.
Yes.
And last GD entry on the same date at 20:18 hours, 20:30 hours. How that can be? How that can be?
GD number 40 might have been recorded by someone else, not by PW1. How does it affect your case?
That has been exhibited. 40 has been exhibited.
Recorded by whom?
Recorded by this man.
This man.
That has been exhibited. I shall take your lordship. Kindly comes to the next paragraphs. In GD number 33 dated so and so, I have not mentioned. Kindly similar. In GD number 33 dated 2nd March 2016, I have not mentioned the registration number of the vehicle which I used. So this GD, left GD was also done by this PW1.
How does it help you?
My lord, it will help me in the way that for conducting raid, this PW had a specific number, GD entry number 33. Seizure affected in connection with what? Seizure affected in connection with what? That has to mention. There was no specific case number, PS case number. That is not natural. But in connection with the general reference that seizure was affected. Seizure list 2 and seizure list 3. Exhibit 2 and exhibit 3 was prepared by this, allegedly prepared by this PW in connection with, in reference to one number. This PW chose not to mention that number in connection with what this seizure affected.
Fine.
The exhibits seizure list does not bear the GD entry number. So, my case, this has been prepared afterwards to implicate us in this case.
What's the reason? What should be the plausible reason?
In every prosecution, the beneficiary is police.
Beneficiary is police.
My lord.
Fine.
In every successful prosecution,
beneficiary is police.
My lord.
Very well. How? How?
But if there is a successful prosecution, my lord, police will be the most rewarded person. Police will be the most rewarded body.
By whom?
By the state, because this is a state case.
So according to you, police in all cases should be considered as interested witnesses because with their success they will be benefited by the state with award
If
or
there is a-
whatsoever.
Suppose if there is a false implication, if it comes, there will be a stigma on the department to bring home charge.
These are all not necessary to adjudicate the appeal. Come to the point.
Then, my lord, page 10.
Yes.
So I had pointed out, my lord, that
Your point is that scissor list exhibit 2 and 3.
my lord,
They don't bear the reference of GD entry.
my lord.
That is your point. Next.
Because PS case is not impossible, is not possible to refer, my lord.
Yes.
PS case is not possible. GD entry was there, so my lord, the arrested person, I arrested the accused person on 2nd March 2016 at 1850 hours. After that, I, along with the accused person with the Caesar Alamat and other documents, went to STPS, diarized the entire fact, written GD being number so and so. Then I prepared the letter of complaint addressing to OCSTF. It was computerized, typed by me, and it bears my signature. This is the said written complaint containing 2 pages. Complaint is marked exhibit 3.
Right.
I submitted the written complaint before OCSTF along with the arrested person, seized alamas, and other documents. Perused the letter of complaint and endorsed the case to SI of STF Shankar for investigation. This is the endorsement of OC and in the FIR with the signature and the official seal. This endorsement was done in my presence. I know the handwriting of and the signature of the OC Mrigango Mohan Das endorsement G.Y.Y. Thereafter, SI Shankar took up investigation and filled up the FIR. I put signature in presence in the FIR as a complainant. The formal FIR is rendered to the exhibit. This is the said FIR. This is my signature in the formal FIR. Signature of the witness marked exhibit 4. I can identify duty entry number 33. It was
Why according to you, factum of seizure should be disbelieved?
Well, that is from the PW2 and similar.
Yes. Why? What did they say? You have to come prepared to the point. Now, while assisting the court, if you start reading, then
comes to my cross.
Your cross at
page 22. Our cross.
Page 22.
Page 22.
That is PW1.
PW1.
So far PW1 is concerned, you have stated that seizure lists don't contain the GD reference. Thereby, it should be presumed that.
And it was carrying by us in left hand or right hand.
Yes, there is no indication by which hand the bag was being carried by the accused person. It makes the factum of seizure doubtful. That is PW1. What about PW2 and 3?
PW2, Paman Pandya, he has, in his cross-examination, he has said whatever he has deposed before the court, that was for the first time he did not.
Yes. He was not examined by the IO according to you and according to the witness also. Fine.
Kindly takes up his cross.
Yes, he has admitted that. He has admitted for the first time I am stating before the court.
My lord. And my lord, page 26.
Do you find him worth credence or he was not telling the truth? PW2.
PW2, my lord, what has been disclosed by him for the first time, my lord, it has got, my lord, no evidentiary value, my lord.
No evidentiary value.
No, my lord.
Under which law?
My lord, Evidence Act says, my lord, and there is a judgment, my lord.
Please,
My lord, there is a judgment if your lordship, my lord.
gradually, I can show you plethora of judgment contradicting your view. Evidence Act, which section? Evidence Act says that in absence of statement under section 161,
My lord, kindly takes up, my lord, 145,
145,
my lord, 145, 146.
yes, what does it say?
A witness may be cross-examined as a previous statement made by him in writing or reduced in writing. And relevant to the matters in question.
It is the
without such-
provision, it is the provision
One-
how to contradict
My lord,
a witness
my lord,
with respect to his
My lord.
previous statement.
my lord.
But
As per-
where is the law that in absence of any previous statement,
As per,
this, please, first you understand.
My lord.
You show me the law that imposes a restriction that there being no previous statement, the statement before the court or maiden statement before the court during examination cannot be taken into consideration. It is inadmissible.
My lord, I'm backed by judgment.
You are backed by judgment. Show me the judgment.
My lord, then, my lord, may I come back tomorrow, my lord, with the judgment? I have the judgment.
You should come ready for any question.
My lord, I'm backed by, my lord,
No,
just-
I cannot afford that much time. I am telling you. Whatever point you do have, please come prepared.
My lord.
Otherwise, I will simply start dictating my
My lord,
judgment.
my lord, kindly take this, my lord.
This is
My lord, kindly take this, my lord. I shall refer this judgment, my lord, during.
no.
the course of my-
You must come prepared.
In course of my argument, I shall refer that judgment. In course of my.
So what? I need to go through the judgment. You come prepared. You prepare. You come back with your short note. Don't waste your time by going through the paper book. You come back with short note.
There are other points, my lord.
Fine, you come back, you prepare a short note and come back with all judgments you want to refer to or with points you want to highlight.
My lord.
Very well.
My lord,
When? When?
after vacation,
No. Before vacation.
this side of vacation.
Sorry, I can't afford that time. Before vacation, any day you suggest. You were to show me some good reasons not to accept the version of prosecution witnesses regarding recovery of fake currency note. That's it. So come back. We are today on 8th. So come back on 16th.
16. Can I do that?
Yes, it can be no issue. You just suggested it.
18 by 18.
18th. Very well. You come back on 18th. Sorobu. Heard Mr. Hussain, learned counsel for the appellant. Matter is adjourned to appear on 18th of May, when learned counsel for the appellant is supposed to submit a brief or short note on his argument. You are for the state. Don't expect adjournment on that day. Come prepared.
Any. Much of it.
Next matter, my lord, that matter, my lord, which is
88.
that matter, my larger bench is pending, my lord. Next date is 11, my lord. With the Bharja
Presumption.
489B, my lord.
489B and 489C.
Issue is
Then
pending.
let us release the matter.
No,
Before the larger.
I am appearing in item number 89, arising out of the same judgment. Different two appeals have been filed.
Let all the matters be decided by the honorable special bench.
Point of law before the judgment is different.
No, my
At least my point is different. It's my appeal. If you also think so, so please, my lord, please.
You are appearing
88.
88.
Yes.
For the time being, you are excused. Come, 89.
Then my kindly my matter, my kindly adjourn.
Earlier,
May be released.
No, adjourn, my.
Adjourned. That I will see.
earlier these
Let's-
matters were adjourned on that ground
Yes.
only that it's pending before
My
the
kindly,
judgment.
mildly.
So, my lord, I am not ready that.
Yes, yes.
It was adjourned on the last occasions on the ground that it's pending before the.
No, 88 I am not going to take up.
89 similar matter. My lord.
He has got, according to Mr. Dey, that issue is no way concerned with his appeal.
Today the date has also been fixed before my lord Justice Bagchi, my lord Justice Ghosh, and my lord Justice Joy Singh. That is the larger bench. Today, perhaps my lord Justice Bagchi will not sit because my lord there is an interview of the judicial.
Yes, I know.
That's why the matter will be adjourned till Thursday.
Fine, no issue. I have two options. Either release the matter for consideration by the honorable special bench, or I can adjourn the matter as far as 88 is concerned.
What are the second part?
So far 89 is concerned, according to Mr. Dey, there is no nexus between the issue involved in the appeal and the issue before the honorable special bench.
My points were two points. One, the notes which were allegedly recovered from me, I was not charged for any of the notes. Charges were silent about our notes. From my possession, only my name has been put in the charge. Total 260 notes were found, and from my allegedly from our possession.
Are you ready to assist the court?
I'm always ready to assist.
Then let's take up the matter. When he has no problem, why should we stand in the way?
My lord, my appellate will be.
Yes, it is adjourned. Send it out of list. Item number 88 with liberty to mention. No, there is no point. I will keep it in the list unless that is, you come back once it is over, you mention, it will be included in the list. Item number 88 with liberty to mention. As of now, it is going out of list. Let it be decided then you mention, I will include it.
This matter, so we got is appearing for the state.
Avik Ghatak is appearing for the state. Where is Mr. Ghatak?
He has not called me. He has called me.
You just send for Mr. Ghatak.
I was under the impression it will be adjourned, so I read long back.
According to Mr. De, nothing was recovered from his possession.
No.
He only lent his name.
Recovery is there, but
Allegedly-
charge was not framed to that amount. Total
Yes.
recovery was 2,67,000 and charge was framed 2,60,000.
And 7,000,
From
Seven
there-
notes were recovered, allegedly recovered from the possession of the from appellants, two appellants. 3 notes from Abdul Khalek for 1,000
without framing of charge, how could he be convicted?
Yes, madam, that is the point
Charges
which-
were framed against them, but the amount that was mentioned is 2,60,000, which was not recovered from.
that amount, and only the investigating officer said that I went there, pursuant to the statement of an accused, I went there and found them roaming in the.
Your Lordship will kindly come to page 6.
Sorry, the market.
Record টা দিন আমাকে. Then I am detagging item number 89 from 88.
As you know.
What's the point?
Tomorrow I will take up the matter. If you find
What should I do? What's the point keeping the matter in the list? When it would not be possible.
Actually, since both the matters are arising out of the same judgment, it should be heard together.
Are together, but the issues
That
are
is
different. In
subject to your
his
lordship's-
case, there is no charge. Then
That can be
then
different.
question of recovery doesn't come. The presumption to be drawn from the factum of recovery.
Then have to go through the Caesar list.
One Caesar list.
No. 2 Caesar lists.
So what is same judgment? Technically, it should be heard together. দুটো কি লিস্টে বাইরে বার করে দিন শুধু শুধু সময়
With liberty to mention.
liberty to mention. Part heard, bold.
There we, your lordship, the benches change, we will.
I shall be very happy.
Or let
Don't
it be
be-
after vacation.
Don't be
madam.
self-centered in that.
Let it be after vacation.
But the client will
Adjourn
not be
for, after vacation.
Can after the.
In the meantime, maybe.
Well.
No. Who is appearing? Mr. Basu, are you appearing in that matter? When it is like, no, the special bench.
But I have been told that it will continue till end of June because the
Till end
hearing
of
is still
June.
going on. Appellant, they have just started their argument, and state will submit. The other lawyers are there in other matters, so it will continue.
So it's always better to release the matter
Well, it will-
as of now. In a sense, it should go out of the list with liberty to mention. Let me also forget. No, how could I adjourn the matter for, say, a couple of months? After vacation, there is no, you were saying that it will continue till June.
I've been told.
It may be extended till July. Then once it is over, you come back, it will be included.
Then let the partner be.
Let the matter come in the monthly list of June. If you so desires to.
It will be of no use to you. Because matter will be continuing in the, before.
Fix up a date in the month of June, madam. Let the partner be there.
If I'm convicted, but I'll accept it gracefully. But I want to move. At least my client, my lord, we want.
I
to move
don't
it
want to
further.
carry with me the baggage of parthered, particularly in these two appeals.
But
When
at least, my
the
lord, if
special
lordship
bench,
is-
when the special bench will be able to address the issue, we don't know.
if your lordship,
Then-
my lord's determination is changed, in case we have the liberty or privilege to go to the civil courts or something.
That is what I desperately don't want.
We want to.
ওটাকে এ করে দিন তো দুটোকে out of list করে দিন, with liberty to mention. It is submitted at the bar that the Honorable Special Bench, larger bench, is insisting of the issue as to the presumption that could be drawn of seizure of FICN. It is submitted further that the under such circumstances, both the appeals should go out of the list with liberty to mention once this matter before the Honorable Larger Bench is decided. In your appeal, who is appearing? Yes. Do you have anything really to say? Okay, come. Come.
Let me complete my submission.
What else?
So I have three things I have to point it out. My lord, on the last occasion, has directed me as well as your what has fallen from your lordship, that whether the learned court of session has categorically dealt with this issue while passing the order of conviction. So for the yarding delay, the incident is on 24th of June 2015. My lord, the victim, that is PW7, who happens to be a prime accused.
No. Is this the matter when the victim was produced from correctional home?
Yes. Yes, that.
And there is no explanation.
There is no explanation.
That explanation I have.
Yes, you first explain.
Because if they took the point of delay.
No, I'm not on the point of delay, Mr. Sood. My point is very clear. A man was assaulted in such a manner that he got his legs fractured.
Yes.
Even thereafter, he was not taken to doctor. He was taken to correctional home, and from there, for the first time, he was produced before the doctor on 15th of July, if I am not wrong.
Yes, Lordship. That is PW1.
Lordship,
What is the
I am
explanation?
telling you, Lordship. Lordship, the gist of the case is another case was started. I have got the gist of that case.
At this stage.
Lordship, আরে আমার
No,
ক্ষেত্রে
it's
আমাকে আমার মতো করে প্রেস করতে দাও ভাই।
It's okay.
Lordship, that was 269 of 15. Lordship, in that case, case was under section 302, 201, 34. Lordship, in that case, this complainant, this victim was an accused. Now, Lordship kindly says there, Lordship, in connection with that case, the victim was, the appellant was assaulted. Lordship kindly sees the medical report. The occurrence took place.
First, Mr. Sood, you first tell me, can I look into your CD at the stage of appeal?
From the exhibit file also,
Yes.
that another FIR was there. Lordship kindly sees the exhibit file. That
Then the-
exhibit, page 16 to 18. Your Lordship will get the FIR of that case. Your Lordship.
Mr. Sood, you need to explain.
Lordship, why there was
as to-
delay?
No, not delay. This man, according to you, according to state, allegedly was assaulted on 24th of June 2015, right?
And he was taken into custody in connection with that case. Not
Absolutely.
in connection with this case.
Absolutely fine.
Yes.
Now, because of the incident that took place on 24th of June,
Lordship.
this man sustained fracture injury.
Lordship.
His both legs were fractured. His both legs were fractured.
Yes.
And with other injuries.
Yes.
He was
treated.
The evidence, where is that evidence?
Lordship, that evidence is there.
In that case.
Lordship,
in that case.
Lordship,
Then what the prosecution was doing?
In this case also, your Lordship will get কোথায় PW12 হ্যাঁ তারা ভাই কে বলেছে যে ওকে ইয়েতে নেওয়া হয়েছিল কাস্টডিতে নেওয়া হয়েছিল in that case he has been acquitted.
No, I am not an acquittal or conviction. Just visualize a situation. A man with fracture injury was in the correctional home.
Yes.
And he was brought before the doctor for the first time after nearly a month.
22 days.
After 22 days.
22 days he was taken in connection with that case in jail.
Is it plausible story?
Yes. Yes. That is there.
A man with fracture injury was in the correctional home without treatment.
He was arrested on the same day on 24th.
Yes.
And he was admitted in hospital.
Where is that document?
Lordship, exhibit page 16 to 18. Kindly see.
If they can satisfy this, then only I will get back to you.
Yes.
Otherwise not, otherwise I will pronounce judgment. Yes, page, exhibit?
16 to 18.
Exhibit 16 to 18?
No, Lordship, page. Exhibit page. Exhibit 5, page number 16 to 18. Lordship, may I?
You tell me the exhibit number.
Lordship, exhibit number. Lordship, may I get?
Yes.
Lordship, dated ticket and
what's the name of the appellant?
Name of the appellant is
Mahadev Gorai.
Victim. Victim. Mahadev Bharat.
And the appellant is Sharafat.
There are 7 appellants, Your Lordship.
Yes. Now you see, this is the bedhead ticket. Date of admission is 15th of July.
Lordship, that is in connection with this case. And Lordship, if your Lordship sees this CD, Lordship kindly.
No, I cannot see. Sorry.
Lordship,
I won't see.
This is fact.
I won't even have a peep.
Lordship,
this is an appeal. Evidence is on record.
Evidence. Lordship, kindly come to page 19 of the judgment.
Page
19.
Page 19 of
83 of the paper book. My landed friend is
Page 83 of the paper book.
83 of the paper book. Very good. Yes. Paragraph 2.
Lordship, second paragraph. From the bedhead tickets of Mahadev Garai, exhibit 1.
Yes.
1 have found there are fracture of both bones, forearm, right side. He has also fracture of fibula on his right side. He had head injury. So there is clear evidence of grievous hurt. PW7 Mahadev Garai has stated that he was admitted in hospital for 25 days.
Mr. Sur, please excuse me. Where is the evidence produced by the prosecution that this man was treated by doctor?
That is the evidence of PW7. It has been stated by in the judgment PW7. Lordship,
PW7, what did he say?
Lordship, kindly come to PW7.
No, you have not.
PW7, page 23, cross-examination of 3 lines.
Lordship,
yes.
Today, for the first time, I disclose the fact to
Lordship, kindly come.
PW7 is the victim.
Yes.
Lordship, kindly come.
Yes.
On 24th of June 2005.
Yes.
15 at about 10 a.m. some cows were entering in my
yes, that is the evidence,
they tried to cow. On that date in the evening at about 4 p.m. Enadul Khan, such and such, such and such, such and such, and others entered into my house and assaulted me.
Mr. Shur, please. You have to show me by document that the evidence of PW1 should not be acted upon. He was actually treated by some other doctor in some hospital. Otherwise, your case is
Yes, in the
sorry.
hospital that I can show from the.
No, from the city, that is not the thing.
Lordship, enamel hit me on my head by Tangi.
Yes, that is there. But everything
I
what
was admitted in hospital for 25 days.
fine, where is the
Then I was
document?
referred to PG.
Where is the document?
Lordship, it has come in the evidence that he was admitted in hospital for 25
Yes, he was
days.
admitted, but on and from 15th of July.
Yes, and no documents in regard to PG
Then,
hospital.
then I was referred to PG.
Fine, but
So after 25 days,
after 15th of July, where is the document that he was admitted on 24th of June?
Lordship, kindly give me some time to prepare myself.
It will yield nothing.
Lordship,
I have gone through the paper book and the documents.
My lord, we'll kindly have a consider the first 3 lines of the confirmation of the brief. First 3 lines. Today, for the first time, I disclose the fact to the court. Prior to today, I have not told police or any authority about the incident. What remains? This is number 1. My learned friend is relying about the PG doctors. None of the doctors attached to PG hospital has been examined.
Yes, sir.
None of the documents with regard to the treatment by PG hospital has been exhibited. But will kindly consider the evidence of BW9, the investigating officer. He destroys the prosecution case, and that has been observed by my Lord Justice Chowdhury at the time of 389(1) application.
Lordship, their evidence, the
Whose
GW.
Mr. Shoot, it is your case.
Lordship.
So basically, you were to prove beyond reasonable doubt.
Lordship.
Now, your case is Mahadev Gorai was assaulted by the accused person.
Lordship.
Mahadev Gorai claims that he was assaulted on 24th of June,
Lordship.
doctored on 15th of July while attending Mahadev Gorai for the first time after 22 or 23 days.
After being released on bail in connection with that.
Whatever. So you want this court to believe that the superintendent of correctional home kept the man inside the jail with fracture injuries.
Lordship.
You want me to believe this?
He was in the hospital. He was in the
Where is the
Bakura
document?
hospital. He was in Bakura hospital.
Where is that document?
Lordship, that document, I can realize the judgment of that case where he has been acquitted. Lordship, from the
No,
judgment.
you know, Mr. Sood, it is not admissible. You failed to conduct the prosecution case the way it should have been.
Lordship, let me go through the.
This particular point has been pointed by your lordship on the last occasion. And it was these to leader, both of us, that whether this part has fallen from the observation of the learned court of sessions. One will kindly have a look into page 92 to 94.
No, there is no way.
Nothing.
Nothing. I have gone through the judgment.
PW1 has totally been.
I have
negated.
gone through the judgment. There is no explanation, even no reason was assigned as to why learned trial court was relying upon this exhibit 1. What is the nexus between this? What happened in between 24th of June and 15th of July? There is no evidence.
And my lord will also find this person has produced by PW1, who is a doctor, and this person has been produced from the jail. That is the deposition of PW1. How can my learned friend say that he was on bail thereafter he has been produced?
Lordship, fact
That's not
remains
the
that
fact.
he was in Bakura hospital for 25 days thereafter, but I can so satisfy your lordship from that
Just
case.
read the testimony of PW1. This man was produced from correctional home.
Yes, page 10.
Yes. Lordship.
And on that day, he was admitted in the hospital.
This is the
So this time gap between from 24th of June till 15th of July, there is no explanation.
That should have been brought into the.
So what should have been done? If not done, then as a student, I should have read the chapters. I didn't read. Resulting is my failure.
Let's say pay.
As simple as that. You want to take time, but I can fix it for orders. There is nothing. I have gone through the entire record, paper book. Still, for your satisfaction, you come back.
Lordship.
When? You were supposed to come back on that point prepared.
Let's say pay. I should have, but.
There is no explanation. On
Let's say
10th,
in the next week, any day.
15th,
Plus,
under the heading for orders.
as you Lordship.
No, I don't find any reason to keep this matter.
Lordship,
Only for your satisfaction.
I shall go through the.
Now this time for your subjective satisfaction, I am adjourning the matter. You come back on
15 at 2 p.m.
Yes, at 2 p.m.
Lordship, take care.
Actually, I was having a doubt. This point must have been discussed by learned trial court,
Yes.
but there is nothing.
But fact remains there was a case.
Maybe, but you need to prove it.
But
You
that
need
should
to
have been
prove
brought
it.
into the evidence.
Please read the evidence of PW9.
That should have been brought into the evidence.
Anyway, deeply obliged.
Fact remains he was in Bakura hospital for 25 days.
Other, he was in 65 days in PG hospital.
15th May.
15
দুটো তো দুটোই হয়।
পাঠাট করে একটু উপরে দিকে রেখো।
হ্যাঁ পাঠাট রয়েছে পাঠাট।
Deeply
But I was before the other bed, that's not what I could cut down here.
It's okay, thank you.
Deeply.
Item number 90, my lord.
Item number 90.
Mr. Anirban Mitra is appearing for the appellant, my lord. My lord, earlier occasion there was a direction to serve notice, my lord, and we were under the impression, my lord, the matter is fixed on 8th June, not 8th May. But my lord, the matter is appearing to the kindly fail lordship takes it up after vacation, my lord. In the meantime, we'll serve a notice to the opposite parties, my lord.
Lord, it was supposed to appear on the month of June, but it was mistakenly appeared on the month of May.
Today.
And today itself.
I have confidence in my vocal cord. I don't whisper. You are in need of time.
We are for the
Don't give me that. It was supposed to appear on 8th June.
No, my lord.
Instead, it appears on 8th May.
Really, my lord, apology.
I am not a soft-spoken person.
Since my sincere.
I shout at the top of my voice, so there cannot be any such miscommunication.
My lord, kindly take it up after vacation, my lord. In the meantime, we'll serve
After
notice.
vacation, yes.
We'll serve a notice, my lord, to the opposite parties, my lord.
Did you comply with the order of the
No, my lord,
court?
that is, my lord, that is.
Why? Be it 8th May or 8th June. You were to comply with the direction of the court. Saurabh, on the prayer of learned counsel for the appellant, the matter is adjourned to appear on 8th of June. Mr. Mondal is in Jalpaiguri.
Yes.
And Mr. Mitra is not prepared. So you are pushing the matter till 8th of
No, my
June.
lord,
Don't
my
do
lord,
this.
My sincere apology,
My lord, I'm praying apology, my lord. I think this is not the, my lord, item number 90, Madurga Trading and Company. My lord, I'm praying for apology, my lord. I've been mistakenly, my lord.
তারা প্রসন্ন কোনটা? যেটা তো এটা ছিল মিস্টার শুড আর না তারা প্রসন্ন ব্যানার্জি এটা কোথায় দেখি দিন তো 90 কি হচ্ছে না that is 80. No, the matter was that Sarafat Ali and 96. ওটা আগে ডেকে দিলেন কেন? What about this 90? Parted method?
Yes, my lord. Mr. Mandal is appearing for the.
My lord, I'm for the appellant.
My lord, my apology, my lord, I've been mistakenly, my lord.
Yes. Yes. No, I thought it was coming serially. Don't do this, don't do this. এরপরে কেউ একজন রেসপন্ডেন্ট ছিলেন না, উনি এসে বলবেন মালাডা লিস্ট ওয়াজ জাম্পড।
Well, I'm for the appellant. Our submission is completed now. It's.
দেখি কি হচ্ছে।
So far as the item number 90 is concerned, my lord, in this matter, Mr. Mandal is appearing for the CBI. In this matter, Mr. Kalol Mandal is appearing for the CBI.
Take the mic. You can't speak loudly. Yes.
Alright, so far as the item number 90 is concerned, my lord. in
Yes,
this matter,
now CBI to address the court.
Yes, my lord.
Where is Mr. Mondal?
Mr. Mandal is in Jalpaiguri.
Jalpaiguri. Then you start.
My lord, I don't have the brief, my lord.
Hmm?
I don't have the brief, my lord. And even I don't even have a
Then not
any
today.
instruction.
Not today on 10th.
Well, kindly make it 1 week's time. Kindly, my lord. Kindly consider.
No.
My lord,
Mr. Mondal will be coming back tomorrow.
Almost on Thursday.
Then let it appear on Thursday, my lord.
Very well. ওইটা not today করে রাখুন, পাশে মার্ক করে রাখবেন।
My lord, kindly makes it on Wednesday.
11th. পাশে ওটা 11th মার্ক করে রাখুন।
My lord, kindly makes it on Wednesday.
It will be appearing on 11th.
Great.
My lord, I'm praying for an unconditional apology, my lord, in that, my lord. 93, my lord. The direction to serve notice, my lord.
সেটা করে দিন তো প্রভু। Heard Mr. Haldar. You are Mr. Haldar?
Yes, my lord.
Learned counsel for the petitioner. The matter is adjourned to appear on 8th of June. In the meantime, the appellant is to comply with the direction given on 1st of May.
Grateful to you, lord.
দেখি আর কি আসে। হ্যাঁ পড়ি। হ্যাপি লাগতো আজকে কাজের কাজ হবে। ঠিক আছে, থ্যাংক ইউ।